I'd like to welcome everyone to the Baker-Hostetler presentation on the countdown to the August 28th compliance deadline with the new New York DFS cybersecurity regulation. I'm Carol Van Cleef, a partner at Baker-Hostetler, and I'm joined by several members of our nationwide privacy and data protection team to share with you today some of the key practical tips that we've been learning as we've been working with our clients through the process of putting together and implementing cybersecurity plans in anticipation of this deadline. So what we're going to talk about today is who's impacted by the new regulation and how is what's being required here different than what's being required under existing laws and regulations, as well as how do you leverage an existing cybersecurity program in an effort to achieve compliance. Importantly, we're going to talk about the compliance deadlines, and then what we want to wrap up with is talking about some of the efforts that you need to take in order to be able to minimize your enforcement risk. So I'd like to turn it over to my colleagues who will introduce themselves.
Hi, it's Craig Hoffman. I'm a partner in Baker's Cincinnati office. I work on a lot of our incident response matters that involve financial institutions and technology service providers.
I'm Melinda McClellan. I'm a partner in the New York office. I also work regularly with financial services companies on a variety of privacy and data security issues.
And I'm Jonathan Foreman. I'm counsel in the New York office, and I work closely with Craig, Melinda, and the rest of the data privacy team. So we're going to start off with discussing what entities are impacted by this new regulation. The regulation applies directly to licensees, but it also affects non-licensees. For example, any non-licensee that has access to a licensee's non-public information or information systems will be affected by this regulation, even though they're not directly regulated by DFS. Non-licensees, and when I say non-licensees, I mean affiliates, service providers, business partners, and counterparties will be affected because licensees will need to address user access and the resulting risks when developing their cybersecurity programs. Now, New York branch offices, which are listed on this slide, present an interesting situation here because the regulation's FAQs indicate that New York branch offices must also comply with the regulation, even though DFS under the Nationwide Cooperation Agreement will continue to defer to the home state supervisor to examine out-of-state banks. And having said that, the FAQs also indicate that DFS reserves the right to examine New York branch officers, and the FAQs also encourage all financial institutions, wherever they're located, to adopt protections consistent with the regulation. Similarly, New York branch offices of foreign banks must also comply with the regulation, but the FAQs indicate they can scope it to the non-public information or information systems supporting the New York branch office's business activities.
So, Jono, I want to make sure I understand correctly. If a bank operates almost entirely in, say, the Pacific Northwest, but happens to have a branch office in Syracuse, is the whole bank subject to this regulation?
Well, the whole bank wouldn't be subject to the regulation. The branch office in Syracuse would be, and they would be still subject to DFS's examination. But as DFS mentioned in the FAQs, they would defer to the home state supervisor to make sure that they're in compliance under that state's regulations. But to the extent they may have any concerns or questions, they do reserve the right to go in and examine that Syracuse branch office.
So I'm going to talk a little bit about the potential exemptions. We've certainly had clients ask, is a part of our business or is our business exempt from this? First of all, you can look on the NYDFS website and look up literally with a search form the entities that the NYDFS regulates, but it is a little more complicated than that, as Jonathan just alluded to. With respect to the full exemptions, there's certain entities that just aren't covered by this or aren't considered under this at all, and that's charitable annuity societies and non-New York risk retention groups and certain reinsurers, as well as any employees or agents that are already covered by the program of another licensee. So in those cases, they're not required to comply at all. Then we have a set of limited exemptions, and they're limited. This is limited in two ways. First of all, there's only a certain number of them, and second, they're only exempt from certain parts of the regulation. So it's not a blanket, you don't have to worry about this. There are certain sections that you don't have to worry about. Those include entities that have limited operations in New York based on revenue, personnel, or assets, captive insurance companies, and entities that don't directly or indirectly use information systems or access non-public information. That's pretty intuitive since they would have nothing to protect.
So, how limited is limited when it comes to operations in New York?
So they've said the first is if you have fewer than 10 employees, that does include contractors, less than $5 million in gross annual revenue for the past 3 years from your New York business operations, or less than $10 million in year-end total assets. So we haven't had too many entities that actually qualify for one of those exemptions, but there are entities that do, and they would be exempt from certain requirements, such as the requirement to appoint a CISO, the requirement to implement multi-factor authentication, the requirement to do audit trails, other requirements that we'll speak about later, but not wholly exempt from the entire regulation.
Does that 10 employee limit apply in the case of an agent? Because many money transmitters operate through agents in New York, and many of the agents certainly don't rise to the level of 10 employees.
We don't have a specific bit of guidance on that point, but I think that the DFS will probably take an expansive view of what is included in terms of the risk that's going to be posed to individuals by not including them. So, you know, if you have I would say if you're just on the cusp or you're trying to determine whether you should comply, erring on the side of compliance is probably the best idea unless there's a really justified reason not to.
So we talked about the exemptions that are available, and now we're going to talk about what you need to do in order to qualify for the exemption. So what do? You can file a notice through DFS's web portal, and you have to do that within 30 days of determining your exempt status. But as Melinda mentioned before, even though you're exempt, it doesn't mean that you don't have to do anything and you're free from all compliance obligations going forward. You still have to fulfill certain portions of the regulation. For example, a limited exemptee must still notify the DFS of a cybersecurity event. And they also must still annually certify compliance with the regulation.
So do I have to then renew each year after I've made my initial filing?
Well, you do in a sense. Technically, you don't need to file another renewal or another notice with DFS, but the annual certification that's required is in a sense a renewal of that exemption notice, because in that annual certification, a licensee is certifying that is in compliance with the regulation, and only those portions of the regulation that apply to it in light of the exemption. So
how does my exemption become invalid?
Well, an exemption can become invalid in many different ways. But for example, under the situation that we just discussed before about the number of employees or independent contractors that a licensee or licensee's affiliates may have, if, for example, a licensee had 9 employees that are in New York, including those employees of its affiliates, and that licensee hired another employee or another independent contractor that also worked in New York, at that point, that licensee would be over the regulations threshold of 9 employees or independent contractors and would lose its exemption. And the same thing could also happen if revenues or total assets increase over the regulations threshold levels. So what do I do if it becomes invalid? If it becomes invalid, then you have 180 days to comply with the regulation. So it's important to monitor those thresholds that are included in the regulation that give you your exemption status.
So moving on to cover what's new, A lot of the regulators we see who are responsible for imposing cybersecurity regulations, you see them following some of the best practices in other regulations or other laws, and a fair amount of that comes through in what is new under the DFS cyber regulations. The most talked about new requirement is the 72-hour notice after determining a cybersecurity event occurred to report to the superintendent. Anytime you see a mandated response time, especially one that's very short like that, draws a lot of attention. It's not defined what a, quote, determination of a cybersecurity event means. And if you've gone through security incidents, you know it's kind of like a roller coaster. What you know day one may not be true on day 2 or day 5 or day 40. And so really working through what it means to have determined that a cybersecurity event occurred is part of, I think, what we'll see play out. Because cybersecurity event includes business continuity issues, if you have ransomware that infects and shuts down systems, it's pretty hard to say you're not aware that a cybersecurity event occurred. It's a little different when you're doing a network investigation to determine if there's unauthorized access. Some other high-level new requirements, we've mentioned already the annual certification of compliance. Another new is the CISO. And so that's something where you have to designate a person to be the responsible entity for overseeing the cybersecurity program. And that can be someone internal, or it can be outsourced to a third party. If you do outsource it, you have to make sure you have someone in an appropriate level at the company to take responsibility for exercising oversight of the CISO. I think that also means that if you have a chief security officer who hasn't been invited to the board or had contact with the board, now that the CISO is going to be required to annually provide a written report to the board, that introduction is going to need to be made. Another key new requirement is the risk assessment. That's one of those things that security personnel have been told for years. The best way to figure out how to safeguard your environment is to know what you have, where it's at, and that lets you determine how to protect it, and that gets built into this. And also showing up here is the requirement to have an incident response plan. A lot of companies have heard over and over they need an incident response plan, and also that if you're a financial institution, under the interagency guidance on having a security program to protect non-public personal information, you've set up and had your response plan in place. This does add in a couple new things to that. And then the last new requirement worth noting are the audit trails, and we'll cover that in a little more detail later. The audit trails are not just about being able to reconstruct your transactions, but it's also about the forensic data you need to have available that would be designed to detect and respond to a cybersecurity event.
Craig, don't most financial institutions already have an incident response plan in place? And I think you said that this adds a couple things to it. What is different from what they might have in place already?
Right. A fair amount of it is, there's a fair amount of overlap to the response program guidance for financial institutions that has been around for years. And so pretty much every financial institution we work with has some form of an incident response plan. Under the interagency guidance for financial institutions, it was focusing on NPPI, how to detect and respond to an incident that affects customer data. The New York DFS not only covers customer data, but it also covers business sensitive data. So it covers a broader set of data. It also talks about having a plan that's in place to respond to cybersecurity events that affect not only the confidentiality of data, but also the availability and integrity of systems. So this means if you haven't incorporated business continuity response measures as part of your incident response plan, that's something you need to address to comply with the New York DFS. So the New York DFS cybersecurity requirements don't all come into force at once, and there are some transitional deadlines built into this to give companies some flexibility and time to prepare for some of the more onerous obligations that come in. The first compliance deadline is August 28, and it defines the specific sub-requirements that you have to have in place as of August 28th. And so when you do your first certification in February of 2018, all of these sub-requirements that are applicable to the August 28, 2017 transitional period have to be complete and in place when you do your February 2018 certification. Some of the more challenging ones then start to get weaved in over time, over the following years. A couple of the requirements are with the DFSs that are interrelated. One of the most notable are the risk assessments. So part of the cybersecurity program is you're starting with a risk assessment and deciding what data you have, what critical systems you have, how to safeguard that data and keep your systems operational. And the best way to do that is through a risk assessment, but the requirement to do a risk assessment doesn't come into play until March of 2018. And the FAQs that the New York DFS have issued make it clear that to the extent a requirement is interrelated, you only have to certify compliance with those that are required as of the time of the sub-requirement being effective. So in August of 2017, you don't have to certify compliance that you've done a risk assessment, and they acknowledge that you may have to update certain things after you do your risk assessment. But in practice, I think a lot of companies, to the extent they aren't already using a formal risk assessment program as part of their upfront compliance efforts, they're already using or implementing a risk assessment program.
So now we're going to go and talk about each of the deadlines. And the first deadline is the August 28 deadline. And it also may be the easiest one out of the 4 deadlines to achieve compliance with. Most of the requirements are ones that licensees have probably already addressed pursuant to existing privacy laws. For example, I'm sure most licensees already use some form of defensive infrastructure, probably have written cybersecurity policies in place, and have personnel that oversee, maintain those policies and those programs. But regardless of the overlap between this deadline and existing privacy laws, there are some items that licensees will need to tackle in order to get into compliance come August 28th. The first of which is designating a qualified chief information security officer and definitely empowering them so that they can take control of the cybersecurity program and the data environment at the licensee. One of the things that the chief information security officer will need to do is update the cybersecurity policy, which will need to be approved by a senior officer of the licensee. The second big item that the August 28th deadline presents is ensuring that the policies and procedures employ provisions that are consistent with the regulation's definitions of non-public information and cybersecurity event. And this is something that Craig had mentioned before, is these new definitions will affect at least 2 things. They'll affect both how access limitations should be tailored come August 28th, and they'll also affect how procedures should be devised to identify and report cybersecurity events to DFS.
So after we get past that deadline, the next one up is March 1st, and a few more of the requirements come into play there. The first one, Section 500.09, conducting a risk assessment, the periodic risk assessment requirement. There are some limited requirements around exactly how that is supposed to be carried out. It is somewhat interrelated with the requirement to prepare a cybersecurity program. The requirement that the CISO report to the board of directors, as John has alluded to, the CISO has to provide a report to the board of directors on the compliance of the program's compliance, and it kind of interlocks with the board's requirement to certify compliance. to the department, because they will need to know from the CISO, ostensibly, what the company or entity has done to comply, so they can comfortably certify that they've complied. The employee training requirement comes into place. Again, most entities in this space should already have cybersecurity training in place for their employees, but to the extent that the program hasn't been formalized or isn't maybe up to speed, or it needs to be amended to adapt to some new portions of the cybersecurity program, that would have to be up to date by March 1st. The continuous monitoring or annual penetration testing or vulnerability assessment requirement, and they've made clear that it's effective continuous monitoring. So either you have to be able to prove that it's effective continuous monitoring, or do the penetration testing and vulnerability assessments. And then the requirement to employ multi-factor authentication also comes into play on March 1st.
Melinda, can an entity wait until March 1 to do the risk assessment, especially if the program is supposed to be based on the risk assessment? That's
an interesting point, and as Craig indicated, the NYDFS has made clear that, yeah, this requirement isn't in place until March 1st, so if you haven't done that until March 1st, you wouldn't be in violation. However, it would be difficult to establish a cybersecurity program based on a risk assessment if you hadn't done one. I think we would say it's most entities are doing them, and it's best practice, and perhaps the way we would interpret the March 1st deadline is that's when you would have to have it documented or be able to demonstrate to the department that you actually conducted the risk assessment. Something's probably going on in the interim.
Picking up then on the September 3rd, 2018 deadline, you add in requirements for audit trails, and that includes both the ability to establish and reconstruct financial transactions, and you have to maintain those for 5 years. The audit trail related to detecting and responding incidents you have to keep for 3 years. There are also requirements that come into play for disposal of customer information you no longer need for operations, which is, I think something companies across all industries struggle with. After you collect it, it gets stored in lots of places. The ability to go back, find that, determine what's no longer necessary, and get rid of it, I think is one of the challenges companies are going to face in meeting that deadline. The secure application development practices, that isn't just your internally developed applications, that's also any external applications you use, and especially as you use more and more cloud-based applications, your ability to assess, test, and determine the security provisions in place for cloud-based apps really is all across the board depending on the vendor you're using. One I think a lot of companies expect to have trouble with is the obligation to encrypt non-public personal information in transit and at rest. The classic examples of AS400 servers or other old servers that are part of running business operations and technology operations that you just simply can't retrofit to work with encryption technology is something that if you haven't already addressed, you're going to have to address it by September of 2018. And the last part, the user activity monitoring, is another challenge area. If you have employees who have legitimate access to sensitive data as part of what they do, the ability to monitor and determine when they're deviating from the legitimate use to the non-legitimate use is something a lot of companies struggle with. And the other part of that user activity requirement is in an employee awareness and training, which we see a lot of companies have in place already.
Craig, which of these requirements would you say are likely to be the most difficult or most challenging to implement?
I think probably the encryption of data at rest, followed then by doing good analysis and testing of external applications.
So then the next deadline will be March 1st, and this is the one that concerns the risks associated with the third-party service providers. And again, financial institutions subject to GLBA have already been subject to requirements to protect their systems that are accessible to third-party service providers. As we know well from our incident response experience, behind employees, vendors or third parties that have access to your systems are one of the prime vectors of incidents, security incidents. So it's important to get your contract provisions and requirements in place around what third-party service providers can do. Specifically, the Section 500.11 requires that you have policies and procedures in place to address a number of different factors that are spelled out in here. So to the extent your policy currently doesn't actually reference these things, assuming that it's applicable to you, you should probably update that policy to include these points. And then putting contractual provisions in the service provider agreement, and that might be why this is not coming into effect until March 1st of 2019, because it can be a bit of a time-consuming process to amend those vendor contracts, or if your vendor won't go along with it, to find a new vendor, for example.
The last piece is just the oversight piece of how do you show, if you've certified compliance and you were examined, how do you show that you actually have the things in place that you've certified you have in place? It's not enough to just send in the certification when you get examined. You have to be able to document and show the policies and procedures and how you're following them. Companies who have informal risk assessment programs that may largely be in the heads of their security professionals, those may be really effective risk assessment programs, but if you haven't reduced it to a paper that shows how you think about risk assessment and what you do, there's not a requirement that says you must follow the NIST framework or some other mandated framework for doing it, but you do have to define what you're using as your model and method. And so you have to think about, we may be really good at doing this, but how are we going to show people that, beyond just letting them interview our personnel?
Well, I'd like to take this opportunity to thank you for joining us today. Unfortunately, because we tried to condense this into 30 minutes, we don't have any time for the questions we've received. But please feel free. You have our contact information to give us a call or shoot us an email. And we look forward to hearing from you. And good luck in implementation.